Bhanu TV. Today we are back again with another episode on H1B CAP Immigration Workshop. Today I have the pleasure of having a dear friend, attorney Bhanu Ilindra. Bhanuji is a practicing immigration attorney. He's based out of Virginia and he drove all the way 5 hours just for this show. So welcome to the Bhanu TV studio. Thank you so much for coming into New Jersey. For the audience, give a holistic view as to what different kind of an immigration practice you do, and then we will have a specific question for the H1B CAP. So in a minute or two, just give a brief.
Thank you all for joining this show. And my name is Bhanu Ilindra. I'm an immigration attorney. I work for a firm called BBA Law Group PC. We are located in London, Virginia. And I've been practicing immigration law for 15 years. I do all types of immigration matters, especially business immigration, family immigration. I do EB-5, investor visa programs. I do F1 visas. I do tell me what not, any matter that is required, immigration law assistance. We are there basically. That's what we do. And I've been practicing for 15 years now. It's almost 16 years. And my qualification has been good. And I really thank you, Mr. Dev, for giving me this opportunity to be present in Bhanu TV in this program and discuss the issues what we are like to discuss in immigration law.
So what are the most commonly used RFEs we get
for the H1Bs?
For the H1Bs.
See, there are most common issues that occur on H1B cases, especially in the RFEs for the H1Bs are basically, especially it depends upon what kind of a nature of business it is. For example, I'll take an example as an IT consulting company where the employers actually place the employees at the third-party client side, because these are the businesses which usually use maximum number of H1Bs in a year. So I'm taking that as an example to cite what are the common type of RFEs we get for this type of cases basically. Under those circumstances, basically when employer places the employee at the third-party client side, then employer is required to show valid employer-employee relationship. You have to show right to control the employee, how the employer actually determines the job duties of the employee, how do they basically assign the day-to-day tasks to the employee, and what kind of a relationship, contractor relationship employee has, especially with the employer who's filing an H1B petition, especially when he's going to work at the third-party client side. Is he going to work independently at the third-party client side, or is he going to work under the supervision of the under the direct supervision of the employer or indirect supervision of the employer? These are the questions will come. That's a very common question which we see in H1B RFEs. Second one is basically specialty occupation. We all know that H1B is required. H1B can be filed only for the specialty occupation position. The minimum requirement for H1B is that somebody should be able to have at least a bachelor's degree or its equivalent at a minimum in a specific specialty in which the individual is going to work or perform his job basically. So that's one question which will come in basically asking how the position offered to the employee qualifies as a specialty occupation. That means that position at a minimum requires bachelor's degree or its equivalent in a specific specialty. That's very, very important. RFEs we are seeing quite a lot for the past few years. Basically, the number is increased tremendously from 2017 in issuing specialty occupation RFEs basically. Along with them, we are seeing is beneficiary qualifications basically. For instance, if the company files a position software developer for an individual, they're basically asking whether the individual has a bachelor's degree or its equivalent that's related to IT-related field or not, basically. So, educational qualifications of the beneficiary is another question.
One more question on this.
Yeah.
Like after submitting the response, and if consulate is like USCIS is not satisfied with the answer, so can they reject our H1B?
Yes, they can always reject the H1B because approval of H1B is always a discretionary authority of the US. See, as a petitioner or an applicant, it's your responsibility to prove that you have a valid requirement to hire in a specialty occupation position. The standard to prove that you have a requirement in a specialty occupation is very simple. It's the preponderance of the evidence standard. That means it's more likely than not. That is the minimal standard burden of proof. You have to prove as an employer that you have a requirement to hire somebody in a specialty occupation, basically. And in case if the USCIS feels that you're not meeting the requirement, that it's very likely that they may deny that petition. They may deny that petition. And same thing, Deepak, they can deny that petition, basically.
Okay, so in short, the rules are changing this calendar year, this filing year. So it's always better to go with an attorney who's experienced one, who can dot the I's, cross the T's.
Yes.
Rather than someone who has done it before and they are not very familiar with the new laws and regulations. So Deepak, what I suggest to you is, if you are looking to file for the visa, I mean, I personally know Bhanu for more than 10 years now. He's been practicing for 16 years. Questions at manatv.net, questions with plural, questions @manatv, manatv.net. This is the email. You could send us a detailed question, and what we could do is we could forward all the questions to Bhanuji, and he will circle back with you with his questions. For the viewers of Mana TV, of course, he always offers a discounted package, so that's given. He is one of the best I know on the East Coast tri-state area. It's been doing it for many, many years. So thank you so much for your call, Deepak. I appreciate it. Thank you.
Thanks, Deepak.
Thank you. So we just started, and people started pounding on us. So for the viewers of Mana TV, the number to call the studio is 631-867-1293. And I see you've already sent us a lot of questions, and the email where you could send us the questions is questions@manatv.net. So Bhanu, for the viewers, tell us, people always worry, if I'm working with this particular attorney, I mean, does he have a very exhaustive and experienced and diversified experience? So my question to you is, using ITserv and TechServ, these are some of the bodies, professional bodies for IT entrepreneurial organizations, and you have been associated with them for many, many years. My question, which is also an education to the viewers, how these bodies has helped you in terms of getting many cases, many diversified immigration cases, and also tricky questions on RFEs and RFPs. So do you think, ITserv, TechServs like bodies have helped you towards creating the whole, breadth of different styles of H1Bs?
Absolutely, Dave. And you need to understand this. It's very important to have this kind of associations coming together, where all the IT companies are coming together basically, and they're bringing in all the issues they're facing in processing their company's business basically. For example, if they're dependent on the foreign workers, basically like H1B workers and everything, it's important for them to understand what other business is doing, what other companies doing in order to secure the talent which they need for the business basically, right? So these bodies like ITserv, TechServ, these bodies are really helping to come all these companies together. I think there are more than 1,100 IT companies are there in ITserv Alliance basically, right? So all these are small to mid-sized companies, and also large companies are involved, which are basically into IT industry, in the information technology industry. They're all coming together. They're discussing various issues basically. Now there's a general awareness has been increased with the IT company owners and CEOs exactly what to do, how to comply with the immigration law. They discuss with each other, and that's a very good thing to do. And I think it's important that this association has to be formed and come together and discuss various issues. As an immigration attorneys, it also gives us a very good platform where we got an opportunity to meet with all the CEOs in the country basically, and discuss with them what their companies are facing, what they can do, and how they can be in compliance with immigration laws and everything. And I think that is the most positive thing and a good thing happening with these associations. And also, if you look into it, we are seeing some decisions by the USCIS which are basically completely out of line basically. I mean, it's clearly seems like they're basically denying H1Bs on imagined circumstances, not actually based upon the evidence which has been given to them. I think these kind of associations are helping the employers to make informed decisions and file lawsuits against the USCIS. And these lawsuits sometimes really work very well if especially if the USCIS really abuses discretion, because the discretion which they have to exercise under reasonable manner.
Correct.
They cannot exercise it on their own whims or in imagined circumstances. And that's very, very important. If you're bringing together, if you come together, if you fight collectively, then obviously your bargaining power will increase and your representation will increase. So that's why these associations are very important to come together. In that way, my kudos really, I really appreciate the founders of IT Surveillance and Tech Surveillance and all these people.
Correct. I mean, recent years I've seen IT Serve taking a united stand, wherein over 1,000+ employers of IT entrepreneurs coming together, and they have created a coalition towards sometimes the USCIS being not just in some of the cases, and they have taken the litigation. They have taken the litigations, and
some of them they're still pending in the court, but
correct.
Some of them they got favorable decisions.
Correct.
So it's a very good sign that at least now employers are coming out and filing lawsuits against the USCIS when it's required, where it's really required, where we strongly believe that USCIS is under the violation of APA, Administrative Procedures Act. Therefore, I think these companies should go and file lawsuits and get the decisions in the court. In that way, maybe USCIS will stop acting randomly or erratically in making these decisions.
Yeah, I was there in one of the hearing around the same time last year, and that's again the USCIS against the body of IT entrepreneurs, and the judge also felt the same way, where the USCIS was enforcing more power just to harass the small entrepreneurs community. So I'm glad we have IT Serve Alliance kind of forums, which is helping a unified voice for the IT professionals, not only for the employers but also to the employees, and that's a big help coming into our way,
Yes.
as we all hail from the same industry. One of my first question is, I mean, you have been doing this for 16 years.
Yeah.
This year is special, right? In terms of it's a total change management in terms of the new rules and regulations. So what do you think in the last 5 years or last 4 or 5 years of rules, and what's the new process happening in this year? Because that's there's a lot of talks about it, and thus I feel there is a need for having an immigration attorney like you, who has gone through the cycle, who has attended many of these seminars, who studies the new legislations, and will be in a better hand towards filing the process. Yeah. So can you give us, at an overview level, what was the old process and how different the new process is?
See, it's very difficult for me to generalize and explain that, Dave, because you're talking about overall immigration process.
Just filing cases. First, we used to file the entire case. Now, how it is different?
Depends upon what case you're talking about. If you're filing H1B petitions.
H1B petition.
Yes, there is a difference this year from last year, right? Especially for the cap, they made a new rules change, how you can file cases in the cap for a new cap, H1B petitions, basically. We all know that H1B are limited per year, how many H1Bs can be issued per year in the country, basically. That's limitation is 65,000 visas. 65,000. And there is additional 20,000 visas for the advanced degree cap.
Correct.
Exempt people, basically. That means people who have a master's degree or a higher degree from the accredited university and a qualified institution in the United States, then they can basically subject themselves to the additional 20,000 visas. So total number of H1Bs we have is 85,000, basically, right? In them also, basically, there are certain visas are set aside for the Chile and Singapore separately. Okay. 5,800 visas. So the remaining visas are the ones basically available to all the general public.
So about 78,000 and some change.
78,500 basically.
Okay.
Okay. And these visas basically, because there's overwhelming demand for the high skilled workers, and H1B is the most easiest way to bring or hire a high skilled worker by any US employer. So there's a huge demand for this H1B visa program, and we all know that basically. And because of that, every year what happens is when the fiscal year starts, usually the fiscal year commences on October 1 of the prior year. That means fiscal year 2021 will start on October 1 of 2020.
Correct.
And ends on September 30th, 2021. So because the fiscal year starts on October 1 of the prior year of the next fiscal year, and H1Bs can be filed at least 180 days prior to the fiscal year commencing date. So everybody basically goes and submits their petitions on April 1 of that particular fiscal year, of the prior fiscal year, so that they can be eligible to get the cases starting from October 1 of the particular fiscal year. And because of this overwhelming filing happening from April 1, on April 1 onwards, basically in 2008, what USS did, they said that you can file for first 5 days, and then you'll have a lottery. Or if they receive more than 85,000 petitions, I mean 65,000 plus 20,000, if they receive more than that, then they're going to do the lottery for both categories, for the regular quota and
As
also
well as
advanced
additional
degree
quota.
quota, basically,
Correct.
right? So they've given 5 days. They made the change by regulations, by giving a notice and comment, and they implemented through regulations those changes in 2008. So from 2008 till 2019, employers were able to file H1B petitions from April 1 to April 5th with effective start for a date of October 1 of that year for the next fiscal year. And that's what is happening. So what happened is, so thousands and thousands, hundreds of thousands of petitions are being filed from April 1 to April 5th. It was getting logistically very difficult for the USAS. This is the reason what USAS stated when they made the changes to the H1B program, CAP program this year, basically, right? So it's logistically getting very difficult for them. It's getting too expensive and too burdensome for them to receiving these petitions and then running the lottery. And the cases that have been not selected in the lottery, those cases has to be returned back to the employers who are actually submitting them. It's getting too expensive for them because they can't charge money if the case has not gone through the lottery. Therefore, what they did is basically that in 2019, USS announced they're going to introduce electronic registration of H1B petitions that are going to be filed in the CAP season. However, they did not implement it in 2019 because of the logistical issues and everything. But however, in 2020, they implemented that. The electronic registration already started for this year from March 1, 2020 onwards, and it's going to go through March 20, 2020. What requires is employers required to do basic information. They have to provide basic information to register that they intend to hire a particular employee and they want to file an H1B petition on behalf of that employee. That's all they have to say to the USCIS and registration. That is the basic.
How long that window is open again?
For 20 days.
20
Actually,
days.
19 days precisely.
19 days.
From March 1, 2020 noon to March 20, 2020 noon.
Okay.
So it's actually 19 days because 12 hours before
Correct.
and 12
Starting
hours
12 hours
later
later.
is going on basically. So it's actually 19 days. And so it's already started, the window started, and the employers already started registering this registration on behalf of their employees whom they intend to hire or who are already working and they want to continue hiring them by filing H1B petitions for them. They may be working through some other visa program which allows them or authorizes them to work in this country. And that is a major change if it comes to the registration process, because previously that was not required. Employers required to file H1B petition. Now they should not file H1B petition now. What they have to do is they have to register by providing a basic information on behalf of the employer and on behalf of the employee. And once the registration is properly registered, and the proper registration completes only when you do it, fill all the information, submit all the information, and you have to pay $10 to the USCIS online per registration. That's a mandatory requirement. If any employer fails to pay the $10, then it's not going to be a proper registration done. That will never get into the lottery process.
$10 per applicant?
Per registration.
Per registration, okay.
Per registration.
So if there's a candidate and he has a dependent or so per...
It's not for the dependents, it's only for the employee.
For the employee?
Employee.
Okay.
Registration is H1B petition filed only for the employee, not for the dependents.
Okay.
For the dependents, you always file H4.
Okay.
Basically, so it's not
Okay.
applicable, basically. Only for the employee. So, for example, you intend to file 50 H1Bs for 50 employees, then
So
you have to do
50
50 into 10.
Okay.
That's basically $5,000. You have to pay towards the registration fee
Okay.
to the USCIS.
Per petition or per employee?
Per employee, $10.
Okay.
So 50 into 10 basically is...
So if that application is accepted, then the USCIS will ask for a detailed
H1B petition to be filed. So what happens is basically is that once the registration period is over, first they call this as an initial registration period. The reason why they call it as a initial registration period is it's very likely that sometimes that USS may not receive enough required H1B registrations that is sufficient for that cap. Like for example, they have 85,000 petitions
Give
can
and
be
take.
give and take, right? What if they get only 65,000 registrations or 60,000 registrations?
Okay.
They still, the registration is open, right? So what they do is then they will extend the registrations after that.
Understood.
So that's why USCIS announced it saying the initial registration. And if they receive enough number of petitions in the initial registration, then what they're going to do is they do the random selection process immediately from March 21 onwards till March 31st onwards. And they're going to notify all the employers by March 31st, 2019 that whether the case have been selected, sorry, March 31st, 2020, sorry for that, and they're going to basically do the random selection process and notify all the employers. The notification happens by online system where employer account is created, because this is called electronic registration. So they have to submit electronically all this all this information. They'll be notified through their account, by email, and also by letter also. So that's the process which they said. So once they notify that if the case gets selected, then employer has 90 days from the day they notify the case has been selected to submit H1B petition on behalf of that particular employee for whom the registration has been done. So that's a good thing basically.
So from 1st of March till 20th of March is the initial accepting of the registration of the initial registration, and then from 20th of March till 31st of March,
USCIS will conduct the random selection process and start notifying the employers
of those who have applied in the first 90 days.
Basically. Yeah.
Okay, good.
And then
90 days for them to work on the petition.
Starts basically from April 1, 90 days starts, because they can only file H1B petitions within 180 days of the start date. So April 1 will be the within 180 days start date of that H1B petition, because start date will be October 1, 2020. So from April 1 to June 30, they have time to submit H1B petition, because 90 days is basically ends on June 30th from April 1st. So
what's your experience? This is just a question from me, and I have a list of questions where people have emailed it to me, and I'm going to check my email. But this is just my question before I forget. So from 1st of April until June, you could file for the petition if that's been picked, right?
Yes.
Now, most of the visa validity is 1st of October 2020 for the calendar year 2021. How many, what's in your experience, again, it's your personal experience, how often do you see the petition gets approved for the 1st of October, and how many of them get dragged?
Quite a lot.
Quite a lot.
It's always, I would say, it's very difficult for me to tell you the exact probability there and or exact ratio, basically because every case, every lawyer, every company is different, right? So if you have all the documents that warrants approval, then USS will approve that without issuing any RFE or any query to requesting further information to decide the case, right? But in case what happens if the USS deems that information you submitted in the beginning is not enough, and they think that they need some more information to make a decision whether favorable or not favorable, then they will issue an RFE or they'll issue a notice of intent to deny. It depends upon whatever it is basically, right? If they issue an RFE, they give you 84 additional days to respond, and plus 3 days if it's by mail, right? If it's a notice of intent to deny, they'll give you 30 days to respond, plus 3 days if you receive the notice of intent to deny by mail. The reason why I'm saying by mail is because if it's a premium processing cases, they can issue the RFS by fax.
Understood.
That's why. Okay. So that's the.
So that timeline get dragged for the final
beyond
outcome.
October 1 outcome, right? Basically, because it all depends upon how soon employer can respond to that, and then USS has to adjudicate that. Those things can happen basically, and we have seen quite a lot of cases which go beyond October 1, 2020 to get the approvals.
Understood. Okay, very good. So you already answered. There were a couple of callers, they wanted to ask questions on the big change, electronic process, we answered that, and the registration fee also, we answered that. So we self-answered the question for Rajesh Kumar. He had this question, Rajesh Kumar from Boston, Mass. His question was, what new changes has happened, which we self-answered ourselves. Then we have Srinivas Reddy Garu from...
there is one more important change we did not discuss.
Yes.
Very, very important, which came into effect from this year, right? From January 24th, actually, from February 24th, I'm sorry. The importance is basically is that USCIS requires now every, the USCIS requires now every employee, every petition, every applicant, basically, whether he's a beneficiary of the petition or is basically applying self-application for any visa status in this country, to declare to the USCIS that whether they've received any public benefits in the United States, or they're likely to receive any public benefits in the United States. That information is very, very important, because it has been there always. If USCIS deems that somebody is going to become a public charge in the United States, they can deny visa. It's been there all the time. But now, the purview of the particular requirement has been expanded a lot from February 24th onwards.
We have a caller. We have a caller calling in. So finish that your thought, and then I'll put him on a speaker, and then he'll ask the question. Have you finished? Yeah. Go ahead. Go ahead.
I'm just trying to explain.
Sure.
That's what. So that is one major change, because here the regulations now the Supreme Court actually said that USCIS has an authority to determine whether somebody is eligible to get an immigration benefit which they're seeking in the US or not, except one state, which is Illinois. All other 49 states, this rule is implemented right now, because the Illinois case is still pending in the court. Until that case is done, then Illinois residents also will be required to declare whether they received any public benefits or not, if they're seeking any immigration benefit with the USCIS or with the consulates abroad. So that's a huge change, because here USCIS can deem, if they deem that you're likely to become a public charge, then basically they can deny your visa. They can deny you inadmissibility. They may not admit you in the United States. So be careful. If somebody is taking public charge benefits, make sure that you take proper information, proper guidance, count them, which are basically the ones which will cause hindrance for your immigration benefits, which are the ones that may not cause immigration benefits basically. That's very, very important. And this is a major change, and it's a game changer in the immigration law if it comes to various areas of immigration.
And this applies in all 49 states except state of Illinois?
Illinois, as of now. As of now.
Understood. Okay, we have a caller. Please state your name and ask a question for the attorney, Bhanu.
Yeah, hi, good afternoon, Bhanu. My name is Rahul.
Hi, Rahul. How are you?
I'm in New Jersey. Yeah, quick question. If a candidate is filing his extension in his current company, and a prospect organization wants to file his H1B, then what happens? How it materializes?
I mean, they can always file, the prospective employer can always file an H1B petition for you. It is up to the candidate which job they would like to continue, whether they would like to continue working for the employer and the extension filed by the employer, or they would like to join the employer who actually filed a new petition for the prospective position. So it all depends upon the candidate, and there's nothing wrong with it.
But then will there be a conflict at USCIS because the candidate has filed just now the extension, and parallelly he has applied to another organization, and they also filed a new H1B transfer?
As I said, it does not conflict or contradict basically, because the candidate always have a choice for whom he wants to work. If he has a multiple job offers, and if the multiple employers wants to file an H1B petition for them, it is up to that employer basically. Okay, so there is no contradiction here, and there is nothing. USS cannot say that you only have to work with one employer, because that actually results in involuntary servitudes basically, right? That's basically results into slavery. I don't think that is an issue at all here, and there is no contradiction here. So candidate always has a choice for whom he wants to work. He can file multiple petitions by employers at the same time.
Okay, Rahul, for more questions, I mean, again, follow up, you can send him a email to questions@manatv.net, and I'll forward that inquiry to Bhanuji, and Bhanuji can answer that and address that. Thank you so much for calling in. Sorry, the callers called, and I wanted to make sure I received it. We have one more caller call in between. Let me see if I can connect to the person, I believe from North Carolina, 704 area code. Let's see if he picks up. It's on fire today. Everyone is calling. Hello, you are on air. This is Dev from Mana TV, and I have attorney Bhanu with me. Can you please state your name and your question, please?
Yeah, my name is Venu. My question is, I'm on F1 visa. I'm not done my master's yet, so I'm thinking to apply for H1B. I'm looking to apply for H1B because I have a 15 years experience in the past. I want to see anybody. A lot of people was trying to apply for me, but I'm not sure if they have a client letter or I have no offer with the client. Can I still apply with all these consultants offering me taking $6,000–7,000 for H1B cap filing? But I'm not sure if they are genuine or if I'm going to be successful or not. I'm not really sure.
I'm sorry, your name. I think your name is Mr. Venu, right? Mr. Venu, right?
Yeah.
Mr. Venu, it's very difficult for me to answer this question because it's very individual specific, and I do not know the facts and the situation, who are your employers or how they're filing your H1B petition and everything. And I do not know. You said that they're going to take money from you. That is basically
that's illegal.
That's not legally permitted, basically. You know. So I'm not sure exactly how it is basically be done and everything. If you want to talk to me private, you're welcome to call me and reach me. We're very happy to talk. Can you give your number? Private. I mean, yes, you can give us or give him his number.
Why don't you give your number? You're on air.
Because I'm on air.
I know Bhanu's phone number. I'm his client already. So.
Oh, so okay. Sure. That's great. Good. That's great. Then
Good.
you can reach me privately.
Company who has, I'll give a classic example. So our sister company, National Computer Services or Forgen, we're an IT consulting business, as well as we have television channels and hotels, motels, restaurants, and also we have various SOWs. So if I were to file, Venu, in this case, your petition, I will show the client later as a project I have in Mana TV, because a media company, so we need various people to do development, design, and all this work.
Well, Venu, basically what he's trying to say that if they have a job for you in Mana TV, then they will show that SOW for you. If they don't have a job, obviously they cannot show Mana TV SOW for you. Basically, I think Venu, you should talk in private because it's very difficult for me to tell who's your employer is, who's actually what they want to do for you, and why do they want to charge you $6,000, $7,000, which is basically, I think it's very shady because usually regulations do not permit employers to charge anything from the employees. So I would prefer you calling me privately and discussing in detail so that I can advise you whether it's genuine for you or not, whether it's worth for you filing H1B or not through those employers or not. Okay?
Thank you so much, Venu, for your call. We had one more caller. Let me see if he picks up the call. We have another caller. Sorry, we missed your call. Please state your name and a question, please.
I'm Sumit. I did my master's last year, so I just want to know what kind of documents are required for H1B filing.
Okay. So Sumit wants to ask documentation required for H1B filing. Is an OPT.
Sumit, are you an OPT or CPT right now?
Yeah, I'm on OPT.
You're an OPT right now. And what's your major? What's your background?
My background is computers.
Your background is computers. And what is the position you're working for which your employer wants to file an H1B petition for you?
Yeah, so my petitioner is the Sierra's Bank.
Sierra Bank is your direct employer, basically?
No, I'm through another company, it's kind of body shopping company.
Okay, the body shopping company is the one who's going to file an H1B petition for you, not the Sierra Bank, right? I'm asking you, who's filing H1B for you?
The body shopping company, right?
Yeah.
Sumit? Okay.
Okay. So if the body shopping company is filing an H1B for you, basically every lawyer has a different way of approach in filing an H1B petition, basically, right? And if we were the lawyers for your company and we are basically filing an H1B petition for you, where they're going to show that you're going to work with the Sierra Bank pursuant to their agreement, either through their vendor or directly with the end client, that is Sierra Bank, basically, right? So we prepare the case accordingly. Basic information, what we require from an individual like you is your educational documents, your experience letters, your passport, your I-94, your I-20s, your OPT authorization documents, and everything from you. Along with that, your biographic information, all your information from what is required for the H1B filing, basically. And from the employer, obviously we require the employer information, employer documentation, everything, and also the contracts in between you and the employer, and also the contracts between the employer and the vendors or the clients with whom they have an agreement for you to provide services with the Sierra Bank. This is the basic information we require to file an H1B petition. Of course, there are a lot of intricacies into it, lots of details into it. It's very difficult in this call to tell you basically that is enough or not, but this is the basic information which we require in general for filing an H1B petition.
Sumit, you could send information at questions@manatv.net, and Bhanu will forward to Bhanuji, and Bhanu will review it and will get back to you on this. Thank you so much for calling in. That's interesting. So my rebuttal to that is, in this Sumit's case, he is working for the bank through a body shopper. There are times there are 2 layers or 3 layers also.
Yes.
So then do you need a letter from the prime agency, or you need from all the intermediary involved?
See, letter is just one document, basically. So we need agreements between all the layers involved in between.
Wow.
Because we have to establish the relationship between your employer, the actual employer, and the end client. If they're going through the different layers, basically, then we have to establish the relationship between all the layers. So we need to have an agreements, the SOWs or purchase orders or work orders, whatever you have in between, and the letters also stating to their contractual relationship if possible, basically.
Good, good, that's good. I have one question from Surjit Singh. Surjit Singh is from Philadelphia, Pennsylvania, and Surjit Singh's question is, what is viewed as multiple filing or duplicate filing?
This is in regards to the H1B cap?
H1B cap.
Cap, okay. See, multiple filings means that H1B petitions can be filed by multiple employers for a same employee for unique, separate, and a bona fide job, basically. So, if, for example, if employer A is filing an H1B petition for employee X for a particular position, for X position, basically, and that X position could be their internal position, or if they're a body shopping company, or if the consulting staffing company, it's going to be for the third-party client location, basically. And third-party client could be a Z client, basically, right? That is one position, that is one petition which they're filing. Second petition can be filed by employer B to employee X directly internally in their own internal position, or they may be filing for the, if they're a consulting business, they may be filing for their client Y, basically. So client Y, client Z are different, and these two positions are completely unique, separate, and a bona fide positions, basically. These are multiple filings, which is absolutely legal. Duplicate petition means if the employer is trying to register for the same employee multiple times to get into the lottery, to game the system, basically. Okay? And also, that how you can say the same employer is basically is that if employer A and employer B registering this H1B to file with client Z only, then it's a duplicate, because they're using the same client, same position, everything is same, they both are filing the same. That's why it's very difficult to differentiate which is a bona fide one, which is not a bona fide one. It seems like you're gaming the system. That's a duplicate one. So if that happens, then the beneficiary will lose both H1Bs. They're going to deny both H1Bs, saying that they're duplicate filing, there is no bona fide position there, and therefore he will lose the benefit in this cap. They have to again file H1B petition in the next cap. However, if you're registering with the multiple employers at the registration time, USS may not know that. If you're registering for the same employer, same client, USS may not know that. However, they will come to know that if these two petitions get picked up in the lottery, and if the employee submits the H1B petitions by both employers for the same client, then USS will come to know that. That is one caveat. That's why USS clearly said in the regulations say that if somebody tries to game the system, basically, and try to take advantage of the system, and on a case-by-case basis, they will determine whether somebody tried to game the system or not. So how does USCIS will define that? Nobody knows. If it's a reasonable, for example, if employers, let's assume that if an employer have an intention to hire 50 employees and they register for 50 employees, some employees register even for 250 employees, 1,000 employers. For example, Microsoft will register for 3,000 employees because they have a requirement to hire for 3,000 employees. But in the end, when they register for 3,000 employees, maybe 1,000 cases get selected in the lottery, they may end up filing only for 500 employees. Remaining 500 employees, they may not be filing. There's a reason for them for not filing those 500 employees, because the one is requirements might have changed from the day the registration has been happened. Second is those employees might have declined their offer, not joining them. There could be other logistical issues, budget issues, whatever it is. They decide not to hire the workforce now, they will hire the workforce next year, basically. So if there are valid reasons like this, then that USS may not consider that they are not bona fide registrations, basically.
Understood.
But somebody, very small company and very thing, if they do unreasonable number of registrations and they get unreasonable number of H1B selected, and if they don't file H1Bs for them and they file only percentage of that, like 10% to 15% of them or 20% of them, then USS may suspect exactly what's going on here. Did this employer try to game the system to get into the lottery for these employees, or actually he had a requirement? then the USS may flag that employer and then look into it. So it's very important. It's a reasonable standard. That's what the USS will look into on a case-by-case basis, on a circumstantial evidence, basically. That's what is very, very important. So that is the major difference between the multiple filing and duplicate filing.
Interesting. So, so from what I understand, if for the same employer is filing for the same employee, but if there are two different client projects, like say for example, I have one project at, I'm just making up, Citibank, and I have another project at JP Morgan Chase.
They're bona fide positions.
So bona fide positions. So then I can file for the candidate for two different positions.
But problem here is, but for H1B cap this year, that is not a possibility. Reason why it's not a possibility is in the registrations, they're only allowing one registration per employee.
Understood. Okay.
Okay.
So in that case, then so can the employee can find two different employers for two different clients?
Yes.
And they can do
yes,
it? Okay.
because they have two bona fide different offer of employments, right?
Understood.
Employer can only register one registration per employee, basically because the employer always have a choice to file H1B petition either with Citibank or with the
JP Morgan Chase,
whatever it is, once he gets selected in the lottery. Therefore, in the lottery, in the registration, they're allowing only one registration per employee. If mistakenly employer registered twice, they're going to deny them as a duplicate.
Wow. So in that case, the employee as well as the employer suffers because of
duplication.
Okay, that's a very good question, Surjit ji. If you have any follow-up questions to that, I mean, questions@manatv.net is the email. You could send us the query, and Bhanuji can look into that and reply back to you. I have Falguni Shah. Falguni Shah is from Raleigh, North Carolina, and her question is, how do you differentiate between in-house project and third-party project location?
Mr. Dev, this is a very case-specific question, I believe.
Okay.
The reason why I would say this is very case-specific question is, what do you mean by in-house project, basically? I mean, if the employer has in-house requirement, then it's an in-house project, right? As I said, employer has to be an actual employer and direct employer. They're supposed to file H1B petitions for whom they have a need to hire somebody in that particular specialty occupation. This question seems like it's basically related to IT company question.
I would assume so, yeah.
Because they're talking about the projects, basically.
Correct.
And so I'm assuming it's an IT company position, basically. And if that is the case, if the company has in-house projects, they're developing products, right? For example,
like SOWs or projects or products.
Products and everything, basically. Then they can file H1B petition for that project. The whole issue is, I think, coming here is basically whether that position is bona fide or not, whether it's a genuine or not, right? That is basically on a case specific. If the employee is just using those SOWs or those projects basically to file an H1B petition for somebody in the cap and then later on moving them to some third-party company, if that is the intention at the time of filing, then it's not a bona fide position.
Understood.
Then it's a willful misrepresentation by the employer, and then employer may have consequences for that, as well as employee also, if employee is also involved in such kind of a misrepresentation, basically. So one has to be very careful in asking these kind of questions, because it's very difficult for me to answer right way. If it's a genuine position, if the employer is going to work on that position, then employer, yes, has a right to file for that position, whether it's a in-house or whether it's a third-party client-side position. And as you said, third-party client-side means obviously they're working at the third-party company.
Correct.
Third-party company is one who actually receives the service of the employee. And for that, you have to establish proper contractual relationship between your company and the third-party company as an independent contractor, where your employee is providing service on your behalf with the third-party company.
Correct.
That's what the third-party company arrangements are, basically.
So Falguni ji, again, the question, follow-up, questions@manatv.net, that's a question you could send it to. We have one more email from Rohini Kulkarni, and Rohini is from Chicago, Illinois. Her question is, well, that's question I think was already answered. Rohini's question was, what are the documents required for H1B filing?
We already
answered that question, Rohini ji. So, so if you have listened to this show, you will have the answer, or else questions@manatv.net. You could, some of these people have already sent us an email, so those questions are self-answered. We have Tarun Sharma. He has a question. Will the H1B visa quota be increased in the coming years?
Do not.
So wild goose. I mean, nobody.
Know.
Yeah. Okay, that's a very generic question, Tarun.
Yeah.
Nobody knows. Even the immigration officer, I'm sure, can't answer that question.
Yeah, everybody's hoping.
Well, we all hope. There was times where we had 135,000
H1B visas.
H1B visas. So
Yeah.
I hope to get the good old days back.
Yeah. Yeah. I know those times.
Yeah.
And
So Tarun, that's a very generic question. We hope so, but again, there is no guidance anyone can give. It's as wild guess as what yours and mine or Bhanu's could be.
Yes.
We have Gopal Dey. Gopal Dey has a question. Gopal Dey has a very long question.
Mm-hmm.
Why are people afraid of coming back to their country for vacation, thinking their H1B visa will get cancelled? Will this fear of cancellation of visa be reduced or eliminated with the new process?
So for the later part, I cannot answer. It's very difficult for me to answer for the later part. The first part is it's very it's all about how the news circle and the media circle happens in the country, and also how the political environment in the country is all about. And people are they basically get scared or panic if they hear any information that is negative in nature. Basically, if somebody tells them that don't go, if they're getting visas getting rejected if they go for the stamping abroad, then they get scared to travel abroad. And the potential of getting visas rejected has increased tremendously in the past few years. If you look into it, there is a bona fide concern for these employees traveling abroad getting visa stamped, basically because we have seen the trend of denying visas in the past few years increased a lot at the consulates abroad. Okay, irrespective whether it's Indian consulates or it's UK consulates, where it is, we have seen the trend that it's been increased a lot. So that particular reason why those statistics actually making people panic to travel outside the country, because they're worried that whether they'll be able to come back here or not, because they already have huge commitments in this country. They've been in this country for so many years on H1B visa. Due to the current backlog with the immigrant visa numbers, they have been stuck in the H1B program for a long period of time, waiting for the green card dates to become current so they can adjust the status and everything. The children are growing here. There are cultural issues for them, because the children grow up here. They don't know anything about their parents' home country. It's no fault of the children, because they did not come into this country on their own, right?
Agree.
They came with their parents basically, and they grew up here.
Or they were born here, or they are born here.
Or they're born here, basically, right? And they're born here, or they brought up here, basically, right? The only thing they know is America. For them, the country is America. They are basically Americans by blood, by virtue, by patriotism, whatever you call it. They identify themselves with America. So that is what really scares them if they have to go abroad, basically, because what happens to their children, what happens to their future, because they vested so much interest here. They have houses here, they have cars here, they have invested properties here, a lot of things here, basically. Children are going to high schools here, colleges here, schools here. What about their future, basically, So that is what really scares them. So, but what I would say is basically do not get scared for that reason, basically, because if you have a proper documentations and everything is valid and bona fide, I did not see consulates denying unreasonably also under those circumstances. And even if they give it 221G, they're inquiring backwards and with background check and everything, and they're issuing visas. So do not get scared, do not get boggled down with this negative fringe media which is going on in the world with the current administration, because there are good things that are also happening in the current administration, basically. I've seen so many people getting visas, so many people able to travel and come back very freely in this country. So yes, the trend is negative for the immigration process in this country, not only just in this government, even in the past government too. It started from Obama era, not just in the Trump government, basically. Trump government has not done anything specially different or unique. They just continued the policies that have been established in the past government, past administration, from Obama administration, especially with immigration laws. So, and especially with the H1B program and other programs. Therefore, do not bog down with this current administration or with anybody, basically, because I think if you are a bona fide guy and if you have a genuine reason to travel abroad and you have a proper valid job in this country, you don't have to worry about I mean, you should be able to get the visa stamped and then come back. And that's my humble 2 cents to all of you. Don't get bogged down with this fringe negative media about the current administration. It's not worth it, because we're seeing a lot of good things also in the current administration.
Understood. Okay. We have Manoj Nair from Toronto, and he has a question. What will ensure that the non-technical professionals will ensure for H1B visa?
No, I mean, this question, I mean, what positions they're applying for.
That he did not.
So it's very difficult for me to answer, because non-technical, the requirement for the H1B is specialty occupation. It could be technical, it could be non-technical. If it's a technical means, if it's an engineering side or if it's an information technology side, then it's technical. But if it's a legal side or if it's a business sides or anything like that, then it's non-technical nature. So it's very difficult for me to tell, basically, right? Because the specialty occupation has been defined by the statute as lawyers, engineers, doctors, teachers, physical therapists. These all basically considered specialty occupation positions, basically. So it's a very broad set of category of professions that comes into specialty occupations, basically. So it's very difficult for me to answer that.
Manoj, have a follow-up questions with the supporting and elaborate your question at questions@manatv.net. There's one more, Shabir Sheikh. Shabir Sheikh is from Detroit, Michigan, and Shabir's question is, what documents are required for CPT filing? Not OPT filing, CPT.
CPT filing? You mean
CPT student filing for H1B.
I mean, you need to have a proper valid offer of employment from your employer, and that offer of employment define what is your job is, what are the requirements are and everything, and also whether it's a paid or unpaid internship, whatever it is, basically. And that offer letter should be submitted to your school DSO, and your school DSO should approve it, and your school program advisor also should approve that, and then your school DSO can process your CPT authorization and I-22U, and that's how we can work with it. That's basically what is required for the CPT authorization.
Okay. A lot of rumors between the CPT and the OPT, I understand. So are there more microscopic views for the CPT applicant in terms of filing for their visa? Is it more cumbersome than the OPT students, or?
No, I would not say that, basically, because the regulations have remained same for all period of time.
Okay.
But it's about how US is viewing the authorization of CPT and OPT is considered valid or not, basically, right? The regulation says that if you already have completed your practical training, whether it's an OPT or CPT, at the same level degree, that means, if, for example, if you are a graduate student here, and you finished your Masters of MS in Computer Science, and you have taken your OPT, and you finished your OPT, and then again if you join Master's degree program in MBA or some other program, or maybe some other computer science program, then you're not supposed to get any practical training in that degree. Like, for example, computers, CPT or OPT, any practical training, you cannot take that. Unless if the program is a basically vocational program, okay? So what's happening is the students, a lot of students, what they're doing is they're completing their OPT and they're joining the same level degree, saying that major is different. No, major, irrespective of what major it is, if it's the same level degree, whether it's a master's level degree, then you are not supposed to get an authorization again there. And that's where the whole problem is. They're getting a CPTs over there, then US is saying that it is not properly authorized, so therefore you're not eligible for CPTs, so you're in violation of the status. Because you're in violation of the status, you're required to go abroad, apply for a visa, and then come back again. That's what the USA is telling. So there's a huge confusion over here, and this I think the school DSOs has to make a very informed decisions over here, whether is it proper to authorize CPT for the students under those circumstances or not.
Okay, well, that's Shabir. That's a very interesting and a good question. I would suggest you to, if you have any follow-up questions, questions@manatv.net is the question. You should drop us an email with the follow-up questions. I think we are covering up majority of the questions. I'm just looking. Some of these questions were self-answered. Yeah, one caller also. There are a couple of repeat, the H1B visas, will they increase? We already covered that also. It's a very subjective question. One student asked about the green card backlog and all. I mean, this session is more on the H1B cap visa immigration. So we'll stick to that question. That's kind of a lot of scope for this session. So I'll not take that question. Anything else? I mean, this is like we're coming to the tail end of the show.
Yeah.
Bhanu.
I mean, I can only give my 2 cents basically, and my 2 cents is basically do not lose your American dream. That's my whole advice to everybody who's watching the show is don't lose your American dream. Keep it up, because America is always the country which gives you the opportunity to succeed if you are truthful to yourself and you are honest to yourself. So do not lose American dream. Always keep doing it. Keep having American dream. And one thing is, it's probably the country which can give you the opportunity to do whatever you can do in this country. And God bless you all. That's all.
Okay. Well, what I can tell you to the viewers of Mana TV as well as all our global viewers, it's a land of opportunity. It's a very diverse country. People who have a heritage from India, you'll feel just like an extension of what India is here, because you're basically bouncing into different ethnicities, different culture, and different faith. So this year, particularly, the visa rules are changing, and hence it is more important that's the reason is our efforts to bring in attorneys such as Bhanuji, who has been doing this for 15, 16 years, and they have a vast knowledge, and they could give an open advice, guidance, and suggestions to the viewers, and basically that ease down the questions and the confusion which you may have in your mind. Still there will be a lot of questions and still be a lot of confusions, and hence I request you all to after watching our show, if you still have any other questions, you're more than welcome to send us a question at our mailbox, which is questions with an S, questions at manatv.net, and we'll make sure to forward all those questions to Bhanu, and Bhanu will review them, and to his best efforts he will try to answer those questions. If any one of you in this visa cycle looking to file for your visa, Bhanuji will have a special promo working with Mana TV. So Mana TV 2021, that's the promo code, Mana TV 2021. Whenever calling in to Bhanu's office, you may give that promo code, and you could put your case file in. As he rightly said, this clock is ticking. You must file on or before 20th of March 2020
for H1B
noon
cap cases,
for H1B cap cases. So if you are an H1B cap case, you barely have another 11-12 days left. So please approach Bhanu, or you could approach us, and we'll be more than happy to put forth those cases. Bhanuji, thank you so much for driving in from Virginia all the way to New Jersey. Please convey regards to the family.
Sure.
For the viewers of Mana TV, this is me, your host Dev Karlekar, along with Bhanu, and going over the H1B cap immigration. Thank you so much for watching us. Thank you.
Thank you. Thank you, Dev.